If a homeowner defaults on a mortgage, the lender may want to foreclose on the home, selling it and using the proceeds to pay off the outstanding loan balance. In PHH Mortgage Corporation versus Barker, we explore some limitations on foreclosure. Denise and Robert Barker had a mortgage with First Financial Bank. When Denise became ill, they failed to make 2 mortgage payments. Once recovered, Denise contacted First Financial about the missed payments. She was told to contact the loss-mitigation department, which would determine whether the Barkers qualified for a workout option to cure the default and avoid foreclosure. Denise did so and promptly completed the department's paperwork. While that paperwork was in the mail, the Barkers received a letter from First Financial stating that their mortgage was in default and demanding payment to avoid foreclosure. They received a second notice 9 days later. But around the same time, they also received a new mortgage coupon book that listed a higher monthly payment amount. The book arrived without any explanation. The Barkers assumed it resulted from the loss mitigation paperwork and effectively reset their mortgage. They started making payments, delivering checks each month to the local First Financial branch, which the bank accepted. First Financial's corporate office subsequently sent refund checks for the payment amounts, stating that the Barkers' mortgage remained in default and was under review for foreclosure. But the Barkers claimed they never received the checks, and they were never cashed. Unbeknownst to the Barkers, First Financial sold their mortgage to PHH Mortgage Corporation, and PHH then filed a foreclosure action. Uncertain of PHH's connection with First Financial, Denise still made 2 more monthly payments to First Financial. When she tried to make a third payment, First Financial refused to accept it at PHH's direction. PHH subsequently moved for summary judgment, arguing that the Barkers were in default and PHH had an absolute right to foreclose. The Barkers countered that there was a contested fact as to whether foreclosure was appropriate. The trial court held that in the interests of equity, foreclosure was inappropriate and the mortgage must be reinstated. PHH appealed to the Ohio Court of Appeals.